This is our second interview with Eric Anderson, a man on death row who has been wrongfully convicted due to corruption of justice. These interviews are to help bring awareness to Eric's case, so he can hopefully find legal help, supporters, and the media interest in order to put public pressure on the San Diego District Attorney's Office to do the right thing and help free Mr. Anderson. My first question is, what is unique and separates your case from so many other wrongful convictions that should make people and potential lawyers interested in your case?
First, there's no physical or corroborating evidence that links me to the murder. It isn't just me saying this. Read for yourself the transcripts on my website where my lawyer states these facts and how this case against me is built on lies. Furthermore, there is an overwhelming amount of blatant, outrageous government conduct done in my case in order to get a conviction. I'm not just speculating or making wild claims, but I have and do show proof of on my website. In fact, it was so blatantly done is why I'm able to show proof of it, all of which was only made possible and allowed because the judge in my case, Lance Lewis, not only turned a blind eye to what was being done, but played a part in helping the DA ruling violated common court rules and procedures.
What kind of stuff did the judge do in your case that was out of the norm or violated court rules and procedures?
Well, on my website, all of this is carefully laid out and explained with the documents to show and prove all of this. But I will cover some of those issues right now. First, the judge denied a motion for severance of my co-defendants in my case, even though the lawyer for Randy Lee told the judge that he is planning to act as a second prosecutor against me. This is known as an antagonistic defense and isn't allowed based on due process, since he isn't bound to any of the ethical rules a prosecutor is, and was able to make speculative claims against me with different theories of the case against me, and it should be noted, Hans lawyer more or less did the same as well. So the jury ended up hearing multiple theories of this case against me, which I was the focal point of their attack. Meanwhile, my lawyer was left with her hands tied and not able to fight back.
What do you mean your lawyer had her hands tied and she couldn't fight back for you?
It's due to a few of the judge's rulings that prevented her from putting on a defense. One, he denied my trial lawyer the right to put on third-party culpability defense. Basically, this means she wasn't allowed to present any evidence or a defense that someone else was involved, even by naming the third person. Nor could she question witnesses about this. Then my lawyer was denied the right to present gang evidence that would have shown all my co-defendants and at least 3 witnesses against me were all either part of a gang or were associated, which in contrast would have shown I was the only outsider. If gang evidence was allowed, this would have blown a massive hole in the prosecution's case claiming I was the ringleader. It would have made his theory of this case ridiculous. So the judge enabled the prosecutor with this wrongful conviction.
Is there anything else about what this judge did?
Yes, during the jury selection, Hanshu went from being a co-defendant to being a state witness. This violates a court rule often referred to as the 30-day notice of evidence rule. Basically, the prosecution must submit all evidence and witness lists to be used 30 days before trial starts. Yet, this gross violation was made worse because the trial had already started. Also, what is important is the reason it was done. The prosecutor in my case had hoped to ambush my trial lawyer with Hanshu's testimony at the last minute with the likely intention of hoping my lawyer wouldn't be able to investigate Hanshu's statements and uncover the clear evidence that was out there that Hanshu was lying while holding the trial. Keep in mind, the prosecutor already knew and had evidence in his possession that Hanshu was lying. However, my lawyer was able to find this evidence of Hanshu's perjury, like my cell phone records, the alarm company records, and the testimony, and a host of other things. What is more outrageous is once my lawyer points out in court evidence of Hanshu's lies, afterwards the DA investigator gets on the stand and flat out lies about evidence that doesn't exist in order to create confusions in the jury's mind if Hanshu did lie or not. Check out my website for the details and documents on this subject.
So the judge allowed perjury by the prosecution side?
The only thing the judge decided the record needed to be corrected on was about what the DA investigator testified to on evidence that doesn't exist. There was no police report of a crime that would have corroborated Hanshu's testimony. This was only decided after a sidebar with the judge and my lawyer putting him on the spot. So, there was a stipulation read at the end of the trial, but it was only stated as the facts that are correct. It became insignificant because it was read nearly 2 weeks later, and it didn't make any reference to why the stipulation was being read in the first place. Was due to this investigator had lied to the jury. The jury was left in doubt if Hanshu was lying or not due to this investigator's perjured testimony. Really, my lawyer filled big time with this and how she should have handled it. She should have dragged his ass back on the stand and made him plead the fifth like what was done to Mark Furman in the OJ case. Nor was there any correction of the record of the state's two main witnesses' perjury, and the judge did cover for the prosecutor and allow him to flat out lie in his closing arguments about documented evidence.
You said the judge covered for the prosecutor and allowed him to flat out lie about documented evidence to the jury? Please explain.
What I'm referring to in particular is what the prosecutor said in my closing argument. He flat out lied to the jury about Hanshu's plea deal. The prosecutor told the jury that Hanshu was free to say whatever, that he could have blamed this crime on Martians and he would have still gotten his deal. But this wasn't a slip of the tongue mistake, because my lawyer did object, saying he's mistaking the evidence. Now here's where the judge covers for him by telling the jury, this is an argument. I'm going to allow Mr. McAllister to argue his viewpoint. Keep in mind, this Judge Lance Lewis knows this is a lie because his signature is on this plea deal. This plea deal locks Hanshu into his free talk statement as being the truth, and any deviation of the truth or lie could cause him to lose his deal, and he becomes subject to prosecution for perjury. This prosecutor goes on about this lie and how he could have said Martians came down and did it, and he would have still gotten his deal. So what reason does he have to lie? Nowhere in this plea deal is this open for interpretation, that he could claim anything but what Hanshu said in his free talk statement. This should be both shocking and cause people to be outraged by even this being possible in our judicial system. But it happens more often than you think.
Wow. I see why you say there is blatant outrageous government conduct. Well, your time on the phone that you are allowed is almost up. Do you have a closing statement you would like to add?
I would like to add a bit of food for thought about all this. If the prosecutor needs to use what he personally aware is perjured testimony, then have his investigator try to lie about evidence that doesn't exist, then finally tell the jury a bold-faced lie about Hanshu's plea deal, what does this say about his case against me and my innocence? What does this say about the judicial system in general? This is one of the clearest examples of why we need to eliminate qualified immunity. Clearly, this prosecutor, the investigator, even the judge had no fear of any consequences for their action. Where if you or I were to lie in court and commit perjury, our asses would be thrown in jail. If this prosecutor feared the possibility of losing his job and going to jail, I would have never even had a case against me made to trial, because there is no evidence in this case that actually links me to the murder. Last of all, I'm hoping these interviews with the video shots of the documents prove what I'm saying does more than make you believe in what I'm saying, but brings in the help and support I truly need. So if you're a lawyer, a journalist, or someone who is a social media influencer, or even if you're just an average citizen who cares and is willing to get involved, please contact us. We really need your help. Also, I could really use the help of the general public in signing my petition and help me put public pressure on the DA's office to release me. Help me make my interviews go viral by sharing them and contacting those with influence and making them aware of my interviews, my petition, and my cause for justice. I'm not just fighting for my case alone, but I want to bring awareness to wrongful convictions in general, and hopefully, with changes to the law, stop them from happening in the first place. Thank you.
Thank you.